Hey guys, welcome back to my channel. It's Debs. I'm a paralegal and I'm here to talk about legal stuff. And today we're talking again about the lawsuit of Raquel Leviss against Ariana Madix and Tom Sandoval from Vanderpump Rules. So we already discussed her initial filing, and today we're going to talk about Ariana Madix's response, or specifically her motion to dismiss Raquel Leviss's lawsuit, at least against her, in the revenge porn. So it says that Ariana Madix has filed an anti-slap motion to dismiss Rachel Leviss's revenge porn lawsuit against her and her ex, Tom Sandoval. According to legal documents obtained by ET, the 38-year-old former bartender is asking a Los Angeles court to throw out the February suit that Leviss, 29, filed, in which she accused Sandoval and Madix of creating revenge porn, eavesdropping, intentional infliction of emotional distress, and invasion of privacy. In their new filing, Madix's legal team calls Leviss's case an example of a slap suit, a strategic lawsuit against public participation, and asked that all three of the claims filed against their client, revenge porn creation, infliction of emotional distress, and invasion of privacy, be dismissed. They are also asking that per the anti-slap statute in California, the state where the case is based, Madix's attorney's fees be paid by Leviss, stating that her suit is an abuse of the legal process. A slap lawsuit is defined as legal action taken by one party that is intended to dissuade their critics from continuing to produce negative publicity. By definition, slap suits do not have any true legal claims against the critics, according to the Cornell Law School. Madix claims that Leviss, through her lawsuit, does not seek to vindicate any cognizable rights, but to punish and to deter her and others from exercising their constitutionally protected right of free speech. Contrary to claims that Leviss and her team have made regarding the nature of her affair with Sandoval coming to light, and Madix's knowledge of said affair, Madix's lawyers claim she was in the dark completely with regard to the affair between her then-partner and their Vanderpump Rules costar. Miss Madix did not know about the affair, but on March 1st, 2023, Madix learned about it in the worst possible way by discovering a video on Mr. Sandoval's phone of plaintiff and Mr. Sandoval having phone sex, Madix's legal counsel alleges. Madix's motion to discuss claims that while she was devastated upon making the discovery and did inform her friends and colleagues to the situation, she did not participate in any illegal activity surrounding explicit photos, videos, or evidence of the affair between Sandoval and Leviss. That while she was devastated upon making the discovery and did inform her friends and colleagues to the situation, she did not participate in any illegal activity surrounding explicit photos, videos, or evidence of the affair between Sandoval and Leviss. One thing Miss Madix did not do was share or show any of the video footage she found on Mr. Sandoval's phone with anyone but the plaintiff. In fact, Miss Madix could not have shared such footage because Mr. Sandoval deleted it from her phone within minutes of Miss Madix confronting him, a fact Miss Madix stated in writing 33 minutes after sending the videos to plaintiff. The claim in the legal motion. Leviss's lawyers reacted to Madix's legal filing in a statement to ET, calling her motion in recollection of the events laughable. The only thing more laughable than Ariana's motion is her fairy tale account of how she discovered the relationship from Tom's phone. Meanwhile, we look forward to cross-examining her on her declaration, as we have irrefutable evidence that the videos were distributed, they said. Lastly, forensic expert states that the video is not now on her phone, well after the events in question, and with months of notice that her actions had put her in legal jeopardy. The court has yet to rule on Madix's motion to strike. And this filing came shortly after Madix's own legal team claimed that Leviss is attempting to paint Madix as a scorned woman and TomTom owner as predatory. And in response, Sandoval alleged that Leviss's podcast, Rachel Goes Rogue, is a strategic move to manipulate the narrative. As for Leviss's claims that Sandoval filmed their intimate Facetime calls in which she appeared in a state of undress and masturbating without her consent, His attorneys argue that said videos were allegedly created and shared consensually and that Sandoval merely saved private copies of the videos. Sandoval is also requesting Leviss's lawsuit either be dismissed or amended. I'm guessing, yeah, Raquel's lawyer, I'm guessing, reacted to his response, writing, Sandoval's response in the face of irrefutable evidence that will be presented in court is disturbing. Leveraging such claims for media attention and perpetuating victim blaming is not just deplorable but actionable. Leviss's publicist tells ET in response to Tom and Ariana's filing, in today's age of social media-driven instant gratification, viewers crave immediate answers and frequently indulge in speculation, often resulting in the dissemination of misinformation. Public opinion remains vulnerable to manipulation by meticulously crafted PR statements. Oh, well, this is a PR statement, so it's rich. Okay, and stunts aimed at shaping a particular narrative. It's imperative that such matters be adjudicated through the legal system, relying on factual evidence rather than entertainment rhetoric. This is rich coming from a PR or a publicist. To ensure justice prevails over sensationalism, especially with such serious cases. Okay. So, I mean, I'm from Canada, so I'm not quite sure what anti-slap is or what the laws are, so I guess let's review it together. So, anti-slap laws. What is anti-slap? Short for strategic lawsuits against public participation, and they're a tool for intimidating and silencing criticism through expensive, baseless legal proceedings. And anti-slap laws are meant to provide a remedy to slap suits, to prevent people from using courts and potential threats of a lawsuit to intimidate people who are exercising their First Amendment rights. In terms of reporting, news organizations and journalists can use anti-slap statutes to protect themselves from the financial threat of a groundless defamation case brought by a subject of an enterprise or investigative story. Under most anti-slap statutes, the person sued makes a motion to strike because it involves speech on a matter of public concern. The plaintiff then has the burden of showing a probability that they will prevail in the suit, meaning they must show that they have evidence that could result in a favorable verdict. If plaintiff cannot meet this burden, then suit is dismissed through these proceedings, allowing defendants to collect. Okay. So, kind of sounds like to me it's more so about defamation stuff. And Ariana is being accused of revenge porn, which actually is illegal. It's a crime in California, so unless she's saying that she has the right of free speech to send people's nudes, I don't know, because she admits that she sent it from his phone to her phone, and then she sent it to her phone. So she admitted to that, but I guess that's where, if she in fact did not send it to anyone else and she doesn't have it, then I don't know. I don't know. I'm curious to know. Okay. Let's learn about revenge porn. Under California Penal Code. So California legislators passed revenge porn law, making it a crime for anyone to post online photos or videos of someone's intimate body parts without consent, and is often considered a type of non-consensual pornography. In other words, revenge porn is a phrase that refers to posting of intimate photos of someone on the internet in an effort to get even with them, which is a powerful tool for prosecutors to protect victims that have had their reputation tarnished by another person they used to trust. It makes it a crime to spread online someone engaging in sexual intercourse or performing sex acts without their consent. It's similar to invasion of privacy laws when someone secretly records sexual-related videos or takes photos of someone without their knowledge or consent. Invasion of privacy laws are not the same as revenge porn laws because the victim initially gave consent to take sexual-related photos or videos with an understanding they would remain private, but the person distributes them without consent. In most revenge porn cases, distribution of sexual-related images and videos occurs by posting them on the internet without victim knowing or allowing it. These type of criminal cases or sexting often occur after a relationship ends on bad terms and one of the former partners, typically male, is seeking revenge. If you're accused, you should consult with a criminal defense lawyer immediately. Okay. Anyone who intentionally distributes images of intimate body parts of unidentifiable person or images that depict them engaging in sexual intercourse, sodomy, oral copulation, sexual penetration, or masturbation in circumstances where they agree or understand the images will remain private, and they distribute the images knowing that they will cause emotional distress is guilty of revenge porn. Should be noted that an intimate body part is any portion of genital... Okay, yeah. You intentionally distribute an image when you personally distribute it, arrange, specifically request, or intentionally cause someone to distribute it. So what does the prosecutor have to prove? That you possessed image of an intimate body part or of an intimate body part of an identifiable person. Mutual understanding they would remain private. Intentionally distributed the image. You knew the distribution of the image would cause emotional distress to the person. The victim who is depicted actually suffered serious emotional distress. Revenge porn law also applies when image distribution has chance to incite harassment from a third party. In other words, knowing that a course of conduct directed at the victim that a reasonable person would consider annoying or alarming when the distribution of the image doesn't serve a legitimate purpose. I don't know. Well, because, I guess it depends what you consider distribution. Is her distributing it to her? Is that considered distribution? Or would it have to be like a mass production? Or, I guess, when it says what do they have to prove, it doesn't necessarily have to prove that you posted online, but that you distributed it. And I don't know. Yeah. So how to fight it? So you have to show, to defend yourself, you could say lack of intent. Recall elements of the crime above that states act of distributing sexual related must be intentional. We might be able to make the argument the upload was made by another individual or it was accidental. Consent. Recall revenge porn where it states only criminal act when there was a mutual understanding that the images would remain private. We might be able to make a reasonable argument alleged victim gave consent to post the images or videos online and no prior understanding they would not be distributed. Or prove there was an actual agreement the material would be posted online. Lack of emotional distress. We might be able to argue that you didn't intend to cause the alleged victim emotional distress or that they didn't suffer serious emotional distress. Recall the prosecutor has to show the victim sustained serious emotional trauma. We might be able to cast doubt on the actual level of alleged distress by the victim. Unidentifiable victim. Recall again that in order to be convicted of revenge porn, sexual related material has to be an identifiable person. We might be able to make an argument the person in the images or videos can be positively identified. If we cast reasonable doubt regarding the material, then you could have a good chance at avowing conviction. That makes me feel like, well, wouldn't that mean then that at some certain, I guess, maybe they would probably could redact it or something, but at a certain point, these videos or images would be called into question. They would have to be produced as a form of evidence, I guess, which that would kind of suck because more people would see it, I guess. But I don't know. Okay. So, what Ariana Madix did was she tried to get it dismissed. Right, yeah, I read this one. So she tried to get it dismissed by saying, those things, which we just reviewed. I'm kind of tossed on this one. But, so basically, Raquel Leviss, she won that motion to dismiss, So Ariana tried to get it thrown out of court, and they sided with Raquel. It said, the writing on the courthouse wall pretty much indicated where things were going on in Raquel Leviss's revenge porn lawsuit against her former Vanderpump Rules, Ariana Madix and Tom Sandoval, but now it's official. After a hearing Thursday morning in DTLA on Madix's motion to have her long-term boyfriend, ex-lover legal action thrown out under the banner of free speech, LA Superior Court Judge Daniel Crawley has issued his order, and looks like the defendants failed to pass the First Amendment test. Madix's conduct is not protected under the anti-SLAPP statute because the alleged conduct was illegal as a matter of law, which means this reality TV thing is going to trial November 3rd next year. Caught having an affair with Sandoval in season 10 of Vanderpump Rules, Leviss saw a video of her masturbating that Sandoval filmed, discovered by Madix on her partner of a decade's phone. The result, the all hell breaking loose of Scandoval. Today, Judge Crawley pulled it all back to reality and signed off on Leviss's February filed complaint going forward. Okay, let's see. Plaintiff has conclusively demonstrated Madix's conduct alleged in the 3 causes of action was illegal, Judge said in his 19-page missive. Therefore, defendant cannot meet her burden to make a prima facie showing that plaintiff's suit arises from any act of defendant in furtherance of defendant's right of petition or free speech under the United States or California Constitution in connection with a public issue, because the alleged conduct is illegal and therefore not protected by the First Amendment or the anti-SLAPP statute. That's Judge's rules. We are pleased at the court's recognition that Ms. Madix's actions were illegal. Leviss's anti-scripted attorney Brian Friedman told Deadline once the order became public. She does not have a free speech right to break into her boyfriend's phone, steal sexually compromising videos of another woman, and disseminate them to menace and terrorize her, the sharp tongue and sharp elbows lawyer added. Her actions went well beyond protected speech, and her anger at Rachel provides no legal cover for lashing out in violation of multiple criminal laws. Things are about to get very real in the revenge porn legal fracas of Raquel Leviss against ex-BFF Ariana Madix and former paramour-ish Tom Sandoval. Los Angeles Superior... Okay, so... Alright, so that was the update to this. So, yeah, there was a judgment made, and judge said, no, her case stands because essentially it's an accusation of something that is illegal. And since that revenge porn accusation, I do agree with that I think the free speech argument was kind of tactless, in my opinion. But, I mean, unless there was, like, she didn't, admit to it, which she did, or at least in some context admit to it, that there was some element of distribution, because she admits that she sent it to herself, so she admits to that. I guess the gray or the nitty-gritty of it is distribution mass distribution, or is it just like, I guess that will come up later on. But while I think like maybe if that was not a part of the case at all, and she was just simply talking about her story, then yes, I do agree that free speech, her being able to talk about her story, would apply. But I guess because she opened up this can of worms, and they're alleging that they have proof that she distributed it further than what she admits to. So I guess that remains to be seen. But, yeah, I guess it'll be interesting. So I was able to find, like, the court documents about this, and we can, like, review them together. So this is Ariana Madix's declaration in support of her motion to strike the complaint. Let's see. So this is what Ariana Madix says. I, Ariana Madix, declare I am the defendant in this action. I make this declaration in support of motion to strike, filed concurrently herewith. As of March 1st, 2023, I've been in a committed relationship with defendant Tom Sandoval for over 9 years. During the evening of March 1st, 2023, I went to a club in West Hollywood, Tom Tom, to see Mr. Sandoval's band play. While playing, Mr. Sandoval's phone fell from his pocket and a mutual friend handed it to me. Because we had been in a committed relation... Oh my god. Sirens again. Oh my god. Because we had been in a committed relationship for so long, and because we trusted one another and presumably did not keep secrets from one another, I knew many of Mr. Sandoval's passcodes, including the one for his phone. I had previously accessed Mr. Sandoval's phone on other occasions with his knowledge and consent. For reasons I still do not know, call it a woman's intuition, when the set ended, I felt the need to check Mr. Sandoval's phone and went to the women's room for privacy. In a locked stall, I accessed Mr. Sandoval's phone and saw text conversations between Mr. Sandoval and the plaintiff that appeared incomplete because portions of them had been deleted, which made me suspicious. While other women waited to use the toilet, I opened the photo app on Mr. Sandoval's phone and was shocked to find a video of a Facetime call between Mr. Sandoval and plaintiff that showed Mr. Sandoval's face in the upper corner while the main image was of plaintiff masturbating. I hurriedly took out my own phone and made 2 recordings of the Facetime video. Prior to that moment, I considered plaintiff a friend and did not know that she and Mr. Sandoval were having an affair. I left the bathroom and walked up to Mr. Sandoval, who asked if I wanted to go into the alley for a cigarette. In the alley, I confronted Mr. Sandoval about his affair with plaintiff. Concerned that people might overhear us, Mr. Sandoval tried to move me away from the club. Around the same time, I sent the videos I recorded to plaintiff, along with the text message reading, "You're dead to me." Copy of the screenshot exhibited or attached. Okay, maybe let's cut to there. So this is between Ariana and Raquel. So while I see the "You're dead to me" text, I don't see the video. And it wouldn't be that it would be like redacted because they would have like blacked it out or like blocked it out. But I don't know why she would lie about that. But I can't remember off the top. Like, if you delete a video, does it say deleted or just disappears? In which case, I don't know. This really doesn't. I don't know. It doesn't really, because she says she sent the video here, but maybe I could have been just deleted from the conversation. I don't know. Let's see. Alright. I did not send the videos to anyone else, nor did I share, display, or show the videos to anyone else. To be clear, I only saw the video of plaintiff masturbating in places secluded from others, i.e. alone in the bathroom stall and in the alley with Mr. Sandoval. I only saw the video. So she saw it, and then I'm guessing she showed it to him. A heated argument ensued between me and Mr. Sandoval, and Mr. Sandoval forcibly grabbed my phone from my hands, causing my credit cards and driver's license to fall to the pavement. I quickly grabbed my cards off the pavement and chased after Sandoval, who had further distanced himself from the club. By the time I caught up to him, Mr. Sandoval had deleted from my phone the videos I had recorded of the Facetime video. Mr. Sandoval also deleted the videos from the recently deleted folder on my phone. Minutes later, I texted one of my friends, Logan Cochran, about what had happened, stating, I called her, which is the plaintiff, after finding it out and texting her the videos from Tom's phone that I took. Tom took my phone and deleted them. Chased him all the way down San Vicente. True and correct copies are attached to Exhibit 2. To her friend. I called her after finding out and texting the videos of herself from Tom's phone. Tom took my phone and deleted them. Chased him all the way down. I called her after and texting her that... After learning about the affair, I began informing my family and other close friends about the plaintiff's affair with Mr. Sandoval, including how I learnt about it by discovering the text and FaceTime video on Mr. Sandoval's phone. Wait. I thought she said... Wait, let's go up. I thought she said that there wasn't much in terms of text. Let's see. I saw text conversations that appeared incomplete because portions of them had been deleted. So, honestly, I have an iPhone. I don't know why I can't remember. If it, like, you know how, for example, like Facebook Messenger or something, like, if you delete the message, it shows, like, delete it. I can't remember if iMessage does that. I feel like it doesn't. Portions of them had been deleted. How would because, okay, so let's say, by her logic or whatever, like, she sent the video got deleted, whatever, so, like, that's why you can't see it in, like, the screenshot. So, if by that, how would she have known that portions were, like, deleted or appeared incomplete? How would she know? You know what I mean? Like, if he deleted anything that would be, like, indemnifying or, like, what, or, like, revealing, then it would have been as if those messages had never even happened, you know? So how would she know? And then at the very last part, it says, I learned about it by discovering the text and FaceTime video. But she said, like, the text or lack thereof was what, like, got her wondering. The lack thereof. So what were the texts then? Huh. I don't know. Okay. So, to carry on, this is the hearing on special motion to strike under anti-SLAPP case management. So this is like the hearing of, like the motion. So Ariana Madix moves for special motion to strike the 3 causes of action alleged against her in plaintiff's complaint, namely the 2nd, 3rd, and 4th. Moving on the grounds that the causes of alleged action against her are barred by CCP because they arise from Madix's constitutionally protected right of free speech, and plaintiff cannot establish by evidence admissible at trial a reasonable probability of prevailing on the causes of action alleged against Madix. Let's see. I wonder if they must have had some type of proof of some kind. Or I guess it's maybe even just the fact that it is like a legal thing. Let's see. So background, it's basically kind of just reiterating what we already read, which is like the filing document, like all the, basically verbatim, more or less. Summary. Okay, so I'm just going to go through this. Alright, complaint. Okay. Alright, so special motion to strike. Litigation of an anti-SLAPP motion provides a 2-step process. First, the moving defendant bears the burden of establishing that the challenged allegations or claims arise from protective activity in which the defendant has engaged. Second, for each claim that does arise from protected activity, the plaintiff must show that the claim has at least minimal merit. As a second-step inquiry, a plaintiff seeking to demonstrate the merit of the claim may not rely solely on its complaint, even if verified. Instead, its proof must be made upon competent admissible evidence. But I guess that's in reference to that anti-SLAPP defense, I guess. A defendant opposing a special motion to strike has the burden to state and substantiate a legally sufficient claim. Put another way, the defendant must demonstrate that the complaint is both legally sufficient and supported by sufficient prima facie showing of facts to sustain a favorable judgment if the evidence submitted by the defendant is credited. Defendant must present competent evidence that would be admissible at trial. Declarations may not be based upon information and belief, and documents submitted without proper foundation will not be considered. The complaint, even if verified, is insufficient to carry the plaintiff's shifted burden. Prong 1. Arising from protective activity. A cause of action is subject to a special motion to strike if the defendant shows that the cause of action arises from an act in furtherance of the defendant's constitutional right of petition or free speech in connection with the public issue, and the plaintiff fails to demonstrate a probability of prevailing on the claim. An act in furtherance of a person's right of petition or free speech is defined by statute to include any written or oral statement or writing made before a legislative okay, so in short, I think we kind of researched this a little bit already, so it's a little bit rereading. Okay, yeah. We've kind of researched on this already. Defendant bears burden of identifying all allegations of protective activity. Conduct in furtherance of the exercise of free speech. Okay, so Madix argues her conduct alleged in plaintiff's complaint concern an issue of public interest and therefore satisfies the test, which therefore establishes challenged conduct arises from protected activity. Excuse me. Madix fails to meet her burden to demonstrate her conduct alleged in plaintiff's complaint arises from an act in furtherance of a person's right of petition or free speech under a United States or California Constitution in connection with the public issue. Plaintiff's cause of action for revenge porn is based on the allegation that on or about March 1st, 2023, Madix discovered sexually explicit videos of Leviss on the mobile phone of Sandoval. Plaintiff alleges that the videos depict her in a state of undress and engaged in a sexual act within the meaning of the statute. Plaintiff alleges Sandoval recorded the videos without the knowledge or consent of the plaintiff, who had a reasonable expectation of privacy that their private communications were not being recorded and would stay private. Plaintiff alleges that plaintiff alleges on information and belief that Madix obtained the videos of plaintiff from Sandoval's mobile phone without Sandoval's authorization. Alleges on plaintiff. Okay, so which Madix admitted to that she took the phone, he didn't know, and she sent it, he didn't know, to herself, or recorded I don't know, but either way she admits to that he didn't know. So plaintiff alleges on information and belief Madix obtained videos from his phone and distributed and disseminated them to others, including but not limited to Madix herself, plaintiff, and other individuals whose identities are not currently known to plaintiff. Okay. Which doesn't really align with the fact that, like, they have irrefutable proof that she further, shared that video. I mean, unless it's been leaked and it's actually, like, online or on Pornhub or something, which, I don't know. To my knowledge, it's not, but I don't know. I'm not on there all the time, so I don't know. But whose identities are not known. So, like, if they have these current, like, damning proof of these other people she sent it to, then you would think that they would know who they are. Or, I mean, whether they know who they are, know who received them, like, whether it's, like, their phone number or what, like, so maybe they don't have proof then, if they're saying not known, because if you had the proof, then I think you would know. I don't know. Plaintiff alleges on information and belief Madix displayed the videos or disclosed their contents to individuals who may not have received them directly, including but not limited to Bravo, Evolution, members of the Vanderpump Rules cast, and other individuals who are not currently known to plaintiff. What? May not have received them directly. What does that even mean? Plaintiff alleges she was not aware that such illicit videos had been captured by Sandoval and could not have consented to their distribution. Plaintiff alleges Madix distributed, disseminated, shared, and publicized. Has this gone, like, public? Not as far as I know, but, I mean, and knew or reasonably should have known that she did not have plaintiff's consent to do so. Plaintiff alleges she has suffered grave emotional, psychological, financial, and reputational harm as a result of Madix's distribution, dissemination, and publicization of illicit videos. Plaintiff alleges illicit videos were recorded when she was in a private residence where her reasonable expectation of privacy was at its zenith. Plaintiff alleges as a direct and proximate result of Madix's actions, plaintiff has and will continue to suffer general and special damages in an amount to be proven at trial. Plaintiff's cause of action for invasion of privacy alleges Madix invaded Leviss's privacy by, among other things, obtaining the illegally recorded sexually explicit footage of her without authorization, and B, distributing, disseminating, publicizing it in a manner highly offensive to a reasonable person. Plaintiff's cause of action for intentional infliction of stress alleges that Sandoval and Madix's acts were at all times extreme and outrageous and intended to cause Leviss emotional distress or performed with reckless disregard for the probability of causing such emotional distress. Here, the gravamen of plaintiff's causes of action against Madix rise from Madix's alleged theft and distribution of private and sexually explicit recordings of plaintiff. Madix's conduct is not protected under the anti-SLAPP statute because the alleged conduct was illegal as a matter of law. The term illegal means criminal, rather than merely violation of a statute or common law standard. If a plaintiff claims that a defendant's speech or petitioning activity is illegal and thus not protected, plaintiff bears the burden of conclusively proving the illegal conduct. A defendant need not prove its conduct was legal in order to meet its burden under the first prong of the anti-SLAPP statute. Court emphasized the narrow circumstances in which a defendant's assertedly protective activity could be found to be illegal as a matter of law. This case, as we have emphasized, involves the factual context in which the defendants have effectively conceded the illegal nature of their election campaign finance activities for which they claim... Wait, is this a reference to another case? Citation, I think it is. Okay, whatever. Okay, here plaintiff has conclusively demonstrated Madix's conduct alleged in the three causes of action was illegal. So the judge found that plaintiff conclusively demonstrated that Madix's conduct alleged was illegal. Or at least that the allegation was illegal? Yeah, conduct alleged is illegal. Madix's declaration establishes that she accessed Sandoval's phone without Sandoval's knowledge and consent. Declaration indicates she had previously accessed his phone without knowledge and consent, but makes no reference to having Sandoval's consent to do this. According to her, she kind of took the phone, he didn't know, and sent it to herself. Madix's secreting herself to access the phone is evidence of her lack of Sandoval's consent to do so. Where she says, I was in the locked stall, he didn't know it, and then I took a video of his phone or whatever, or sent it to myself, something like that. Madix's declaration provides further evidence that Sandoval had not consented to her accessing the videos. When she confronted Sandoval about their presence on his phone, he forcibly took the phone from her and deleted the videos. Sandoval's reaction to Madix having accessed his phone confirms his lack of consent to her doing so. Penal Code 502 makes criminal offense for a person to knowingly access without permission, use any data, and without permission take copies or make use of any data from computer, electronic, and knowingly and without permission access or cause to be accessed any computer system, or computer network. Hold on. The Ninth Circuit concluded that the term access includes logging onto database with valid password and subsequently taking, copying, or using the information in the database improperly. Ooh. So that in itself is also a criminal offense for her to that's wild. Even if you have the passcode, if you don't have their permission, it's yikes. Not looking good. Here Madix declares that she accessed Sandoval's phone surreptitiously and made a copy of the data from the phone, which are the videos, without Sandoval's authorization in the privacy of a woman's bathroom stall. She declares she accessed data that Sandoval did not intend for her to access. Madix declares that Sandoval did not consent to her surreptitious access of the Facetime video on his phone. Madix declares Sandoval grabbed her phone and ran away with it. And plaintiff has conclusively demonstrated Madix's conduct alleged in the three causes of action was illegal. Therefore, Defendant cannot meet her burden to make a prima facie showing that plaintiff's suit arises from any act of defendant in furtherance of defendant's right of petition or free speech. Therefore, not protected by First Amendment or anti-SLAPP lawsuit. At the hearing, Madix's counsel raised Barral versus Schnitt. Let's see. Okay. This is not... Okay. None of plaintiffs' pleaded theories of liability against Madix arise from her public conduct comments regarding plaintiffs and Sandoval's secret relationship, which is not chilled by this lawsuit. Instead, the theories of liability inserted in the complaint against Madix arise from private conduct that occurred between plaintiff, Sandoval, and Madix, despite plaintiff's speculation that Sandoval and Madix may have disseminated the Facetime recording to other unknown individuals. Accordingly, the burden does not shift to plaintiff to demonstrate a probability of prevailing on the causes of action alleged against Madix. So, based on the foregoing, Madix's special motion to strike plaintiff's second, third, and fourth cause of action alleged against her is denied. Yeah, so I guess her admitting to that is also in and of itself her admitting to another criminal offense by, like, yikes. Okay. I don't know. I mean, it's hard not... I don't know. I mean, if you put yourself... It's difficult because from both sides, like, if you were the one that found out, you'd be mad and you probably would want, you know, revenge of some kind. I can understand how you'd be so angry. That's your best friend. So, I can... kind of would make sense. Like, who knows what... if I was in her shoes, I don't know what... God knows what I'd be capable of, you know? However, I can also see how there is also laws in place, you know? There's certain boundaries that you shouldn't cross that are, like, illegal. And also, at the same time, if her... I mean... I'm just curious to know if it was just, in fact, her sending it to herself, or if they are able to prove that she mass sent it out to other people, or that would kind of be the interesting part. I mean, obviously, if she, like, sent it to a bunch of people, then that certainly would qualify as a distribution. But, yeah. I don't know. I can almost, like, kind of see it from, like, both sides. Like, I can see that why you'd be angry and want to get revenge, but also revenge porn is, like, illegal. But also, it's like, is it considered I don't know. What do you guys think? What do you think? Do you think that Raquel is just trying to fish, and she's got, you know, no leg to stand on? Do you think that she must have proof? Or, I don't know. I just want to hear your comments. Like, where do you think this is gonna lead to? I'm curious to know. I'm really, like, in the middle at this point. I don't know. It could go either way. So, it'd be interesting to see what happens. Honestly, I wouldn't be surprised if they end up settling, especially when basically by admitting that she, like, took his phone and accessed it, he didn't consent to it, and then, you know, now knowing that in itself is, like, criminal offense, which she admitted to, I don't know. Maybe it would probably be in her best interest to settle, or I don't know. I really don't know. What do you guys think? I'm curious to hear what your thoughts are. Anyway, thank you so much for watching, and hope to catch you in the next one. Bye.